Hello, everybody. This is Samantha from the law offices of Samantha Wolfe, and I'm here to bring us our next installment in our virtual seminars. Just as a reminder, you can always check out our virtual seminars through our website. We do have a link that takes you directly to our YouTube channel, or you can look us up on YouTube. We have a channel that you can check us out. We post all of our virtual seminars on there. And if anybody ever has any ideas after watching a virtual seminar or just thinking through topics, we're always looking for new ideas that we can bring to you. So we do feel like we like to educate our clients, referral sources, so they know different options that might be available in different areas of law. Today, we're going to talk a little bit about crisis planning. So I'm excited to talk about that. So I'm going to go ahead and share my screen here. Hang on just a second. Let me open up the slide. Maybe that would be helpful. There we go. Okay, I was so excited I forgot to open the slides. What can I say? All right, here we go. So now I think we're ready to dive in. Let me share my screen here. Okay, so today's seminar is When Life Hits the Fan, Have a Crisis Plan. We're going to talk a little bit about what that means and what it means when we're talking about a crisis. So today's agenda, we always like to have an agenda. We're going to define what crisis planning means in elder law practice. We're going to review major long-term care funding sources, Medicaid basics, which can get a little overwhelming. So when I'm in appointments with clients, they're always asking if there are other resources. So we're going to go over all of those numbers. You can always rewind and re-listen and check out these different figures. We're going to explore key planning techniques and timing considerations, and we're going to apply strategies talking about some situations that we've seen in practice. So let's first start by what do we mean by crisis planning? So the first thing is, what is a crisis? Now, if you were to ask that, I'm talking about in the context of estate and elder law, because goodness, there's all kinds of crisis definitions, but I'm talking specifically in our area of law and our practice. So what we would define a crisis is would be a situation in which a client has an immediate need for long-term care that would necessitate estate planning or quick maneuvering, I should say, to reduce the financial burden. Could be that if we have a husband and wife, one spouse needs care and is actually going into a nursing home, that would be a crisis plan that we would need to put together. Or it could be that we have a client, they're single, widowed, whatever, and they're going into a nursing home, and can we protect assets for them? So now ideally, we don't want to be in a situation where we need a crisis plan. At our office, we really try to focus on pre-planning, which is where we have a plan in place, ideally 5 years prior to someone actually needing care. But might be that circumstances arise, or it might be that a client didn't want to do a pre-plan, is what we call it. So in that situation, we'd be dealing with a crisis. So let's talk about it. Why does it matter? Well, long-term care can get expensive really quickly. And especially where we have a husband and wife, you don't want to leave the spouse financially compromised. So when we're talking about crisis planning, we want to try to minimize the impact on the family. Families under stress need a tailored, timely solution to preserve assets and ensure care. So let's talk a little bit about sources of funding for long-term care. So we're talking about long-term care, we're talking about something longer than like a hospital stay. Sometimes people might need rehab, sometimes they can't go home safely. So that's what we're talking about, long-term care. So the first thing to know is that Medicare does cover a portion of this. Now, a couple of things you have to know. First, it does require a minimum 3-day hospital stay, and that would be where you're actually admitted into the hospital. If you're only admitted for observation, then Medicare Part A never gets triggered. So it has to be where you are admitted for at least 3 days in the hospital for more than just observation. And if that would happen, then it triggers Medicare to help pay for that. Now, how it works is that they cover days 1 through 20, and then You have a copay days 21 to 100. Now, Medicare Part A covers up to 100 days. More and more, it's becoming rare to see the coverage up to the entire 100 days. But just know you can get coverage up to 100 days on Medicare Part A. Day 1 through 20, you don't have any type of copay or coinsurance, but days 21 through 100, you are going to have a daily amount that you have to pay. Now, you can have Medigap or supplemental insurance may cover that coinsurance portion that you have. So a lot of it depends on what type of insurance, health insurance you have. Now, you could also self-pay. You can use your own personal assets and income to help self-pay. You can have long-term care insurance. That would be, we see it a couple of different ways. You could have traditional long-term care insurance. You could also have a health or a life insurance, I should say, life insurance policy that has a long-term care rider on it. Now, the long-term care insurance, the traditional long-term care insurance does typically have an elimination period where you have to have needed care for like 90 days before the insurance will kick in. So you want to make sure if you do have insurance that you know when is it triggered, when can it start paying, what's the criteria. And then the last way would be veterans benefits. If you are a veteran or the spouse of a veteran, you may qualify for veterans benefits, and that would be a source of paying for long-term care. Now let's talk about Medicaid eligibility limits. So we have to talk about medical eligibility, income eligibility, and asset eligibility. And I'm going to look at this when I'm talking through this. I'm going to look at it from the standpoint of maybe a husband and wife, just because that might be easier in the example. So if you are applying for long-term care services and support through Medicaid, then there is a medical eligibility requirement. So you need to, the individual who's applying for Medicaid needs to need assistance with at least 2 to 3 of the daily activities of living. So things like bathing, dressing, toileting, ambulating, food prep, all of those would be the daily activities of living. And so you need to have a physician that says that this individual needs assistance with at least 2 or 3 of the daily activities of living. Or you have a severe cognitive impairment, such as late-stage dementia or Alzheimer's. If you meet that medical eligibility, then we just start looking at the financials. But the first hurdle is the medical eligibility. The evaluation process, typically conducted by a physician, social worker, or agency assessor. And usually it's going to include certain documentation like clinical assessments, care needs reports, hospital or rehab discharge summaries. And then they will assess a level of care based on all of those things. And if an individual is assessed at skilled level care, which means that they need nursing home care, and they are assessed at that, then we look at their financial and income. So if we're talking about a husband and wife, and let's just say husband is the one that needs care, they're going to look at husband's income. And what they're going to look at is what monthly income do they have? The monthly income will determine the assets that husband can keep. So typically, most of the clients that we work with, we're looking at the nursing home only Medicaid, and we're looking at the $2,901 a month. So if husband has income more than that, they can keep a certain number of assets. If they have income less than that, they can keep a certain number of assets. Now, deductions that can come out of your income would be health insurance premiums, medical expenses, all of that. Now, if you have, in husband's case, if he has income above $2,901, then he's only going to be allowed to keep a certain number of assets. And usually it's right around $2,000. If husband has income less than the $2,901 a month, then they can keep about $8,000 of assets. Then what they do is they look at the spouse that's not needing nursing home care, and there are certain assets they are allowed to keep. So the first thing you do is you look at what is exempt. So the primary residence is exempt up to the equity cap, which the home equity limit you're going to see on the slide is $730,000. That's exempt. One vehicle is exempt. Irrevocable burial accounts are exempt, and IRAs. So in Pennsylvania, in the example of husband needing care, if wife has IRAs in her name, those IRAs are not available to pay for husband's care. Husband's IRAs are available to pay for his care, but wife's IRAs are not available to pay for husband's care. Then, in addition, the wife has what they call a community spouse resource allowance, which is about $157,000. It's technically $157,920 that they are allowed to basically keep and say, hey, this is mine. So it's up to 1/2, or if you have more, it's $157,920. Now, the assets that would be countable would be bank accounts, CDs, stocks, second home, extra vehicles, all of that. Investment accounts, trying to think, stocks and bonds, all of that would be countable. The other thing that's countable that's not listed on here would be if you have a whole life insurance policy and there's a cash value in that life insurance policy, then in certain instances, if that cash value is above a certain amount, that would be countable too. So ways that as planners, we want to try to help clients is we want to pay down debts, prepay funeral. We want to make sure that their exempt assets are all intact. Then we might do irrevocable annuities, where you're basically converting an asset to a stream of money that pays to the community spouse. So in our example of husband needing care, we might cash out their assets, buy a Medicaid compliant irrevocable annuity that pays to wife. That would then allow husband to qualify for nursing home care, where Medicaid would pay as long as he's medically eligible for skilled level care and the financial criteria is met. And so these irrevocable annuities can help clients become financially eligible. Now, again, if you do it in enough time that you have 5 years, the benefit is that you can use trusts. And if you check out our YouTube channel, we have all kinds of videos about trusts. That's always the preferred method because these annuities, you're locked in. So for example, I've had situations where I'll use the example of husband again, where husband's in a nursing home, we do these annuities that pay to wife, and then husband dies pretty soon after we do it. The problem is wife is locked into those annuities. She can't get more money out of those annuities because in order for husband to have qualified for Medicaid, we had to have it be irrevocable. So if you plan ahead and you are able to make it through the 5-year look back period, the trusts do give you more flexibility. This crisis presentation is in the situation where someone chose not to do the trust, didn't know they could do the trust. Then what do we do when we're in this situation? And that's where you can use these irrevocable annuities. You can also use special needs trusts because you might have, for example, a child that has special needs, and so you can use a special needs trust to protect assets. Now remember, anytime we're talking about trusts, we're typically talking about a 5-year look back period, but there are situations in which a 5-year look back period doesn't apply, and that would be where we use a special needs trust. Then a look back period wouldn't apply. Now let's talk about this slide, which is implementing the plan and timing of the plan. So there are spend down rules. So when you're doing this, you want to make sure that you're spending down debts, home repairs, burial accounts. That all needs to be done before the Medicaid application is filed. Medical expenses, those can be retroactive, meaning that you can establish eligibility earlier if you need to. Now, sometimes in the area of elder law, when we're talking about this type of stuff, we use terminology that I want to make sure clients are familiar with. So the first is the snapshot date. So the snapshot date is the date in which the spousal resource assessment is locked. Usually that means that in our situation where husband goes into a nursing home, that would be the snapshot date. We're looking at what assets did he have at the day he went into the nursing home. And that's how we're determining what do we have to spend down? What do we need to do with the annuity? How much does the annuity need to be in order to make husband eligible for Medicaid? Early asset depletion before this date can reduce the protected share for the community spouse. So you want to make sure that you know what date are we looking at so that we can make sure that we're not spending down more than we need or harming the community spouse. Now, in order to raise cash to complete the spend down, it may mean that you have to liquidate IRAs, may mean you have to liquidate annuities or life insurance policies. That may trigger taxes, surrender fees, or you may lose some of the benefits. So that's where, if you pre-plan and you use trust, you're always going to make out better because you don't have to worry about all of these surrender fees because you aren't surrendering them. You might be transferring them to trust, but you're leaving them invested and intact. Documentation is key. You want to maintain detailed receipts and proof of all transfers and payments because when you're filing a Medicaid application, they're going to ask really for 5 years worth of information to see, are you eligible? Have you made any transfers that would be within the 5-year look back period? So again, documentation is key. And I always warn clients, if you're going to apply for Medicaid, they're going to ask for a lot of documentation. So you just have to be forewarned about that. Okay, let's talk about some exceptions. So we talked about how there's normally a 5-year look back period. There are some exceptions to that. That would be, you can transfer between spouses and there's no look back period. You can transfer to a minor who's under 21. You can transfer to a disabled child or a sibling caregiver child who lived with a parent more than 2 years and delayed institutional care. So these would all be transfers that are not subject to the 5-year look back period. So that's why it's so important to talk to an attorney because they're going to know all these exemptions and be able to walk you through them. Then I have listed some other exemptions. Just know that if you're meeting with an elder or a state law attorney who's talking about Medicaid rules, they'll go over all these exceptions with you. Make sure that you feel comfortable with them. But most of the time, 90% of the situations, there is a 5-year look back period. So again, pre-planning can be really important to make sure you're able to protect assets. Now let's talk about Medicaid recovery, because this is a misconception that some clients have. So they'll come in and they'll assume husband and wife, if one spouse needs care, that their house is available. And so it's always an explanation of your house is exempt because we have a spouse living there. But you have to be careful because there's Medicaid recovery. Medicaid recovery means that someone has died while they're in a facility or receiving Medicaid benefits, and the state can come back and try to recover some of what they've paid. Now, they can do that through any asset that passes through the will. So think about it. If you have a house that's passing through the will and someone passes away, that could potentially be subject to a Medicaid recovery lien. So you have to think through, you might want to avoid probate assets. You might want to use pay on death or transfer on death designations. You might want to use trusts, beneficiary designations. And the benefit there is if it doesn't pass through your will, then Medicaid has a difficult time recovering against it. So you want to make sure you're talking to your attorney about that. You want to make sure they're reviewing documents like the wills, powers of attorneys, the designations that you might have on certain accounts. And that's all to ensure that you're not making assets subject to the Medicaid recovery lien. You want to make sure that you're talking to your attorney about spousal planning. So that would include the community spouse resource allowance. Like, what's that amount? What can I exempt from the cost of my spouse's care? Do I need a monthly maintenance needs and allowance? And that's where the spouse that's not in the nursing home needs additional income to pay for certain expenses. You want to consider disclaimers, special needs trusts, or limiting the inheritance through the elective share. Pennsylvania recovery is probate only, so resources outside the probate estate are not subject to recovery. So again, just talking to your attorney about what assets would go through probate, what would be subject to the Medicaid recovery lien. All right, let's close with frequently asked questions. This is always a fun part because I feel like we've talked about it in other presentations, but until you're actually talking about it in the context of nursing home planning, sometimes it doesn't really hit home. So the first question is, can I give money or house to my children to qualify for Medicaid? Cash gifts. So if you give them cash, if you give them property, anything like that, there's a 5-year look back period. So if my mom and dad decide they want to give me $19,000, which is the federal amount that they can give without triggering gift tax, it's still considered a transfer for long-term care purposes. So if my parents would need care within 5 years, that $19,000 that they transferred to me is subject to their care to the extent that they exhaust all of their funds. So you may not want to add your children to the house. You may not want to give the house to your kids. You may not want to give money to the kids, just because if you do that and you need care within 5 years, it will jeopardize your eligibility. Now, how Medicaid determines that is they will assess a penalty period. And penalty period is a time frame in which Medicaid will not pay for your care because of transfers that you've made. And how you determine the penalty period is you say, okay, if my dad needs care starting today, we're going to go back 5 years and count all the transfers that he made to my sisters and I. In that 5-year period, you're going to total them all up, and then you're going to divide that number by the average daily rate of long-term care, which is $399.80. And you're going to take that the total amount of gifts in the 5 years, divide it by that number, and that will give you a number of months in which Medicaid will not be available to pay for care because of the gifts that you made. And that's what we call a penalty period. Now, exempt transfers would be transfers to a spouse, to a disabled child, or to a caregiving child that has provided care in your home for 2 years. So you always want to make sure you're consulting with your elder law attorney before you make transfers. I can't stress that enough because for federal, you're allowed to give $19,000, but for Medicaid purposes and long-term care purposes, you are not permitted to gift $19,000. You can, it's just it's going to be considered an available resource for 5 years after you do it. So will Medicaid take my house after I die? So this is the Medicaid recovery thing that we were talking about a couple of slides ago. Medicaid may seek reimbursement through estate recovery upon a recipient's death. In Pennsylvania, recovery is limited to the probate assets or assets that are passing under the will. So the short answer is yes. The Department of Human Services, when you die, can recover against the value of the house if it's passing through your will. So you just need to think through, should I use a trust? Should I use a deed, whether it be a life estate or whether it be joint ownership deed, to try to avoid a Medicaid recovery lien on the value of the house? So you just want to consult with your attorney and think through that. I still think, again, if you can pre-plan and enough time for the 5 years to pass, that's always ideal. And you can protect your house using a trust if you would want to do that. What happens to my spouse if I go into a nursing home? So the short answer is that your spouse may be left financially compromised. So remember, they do get the exempt assets. So if you do have a house, the nursing home can't force the sale of the house to pay for one spouse's care. The community spouse would get to keep their vehicle or a vehicle of highest value. They'd be able to keep their IRAs, and they'd be able to keep the community spouse resource allowance, which is $157,920 in 2025. In addition, if the spouse needs additional income to pay for expenses and they themselves don't have that income, we can divert some of the institutionalized spouse, and that's the spouse that's in the nursing home. We can divert some of the income to the community spouse if certain criteria is met. So again, it's just making sure you're thinking about, how do I protect my spouse? Now, again, if you use a trust, you would be protecting your spouse because those assets after 5 years would not be available. So again, I always encourage clients to think that way as opposed to saying, let's wait until we're in the crisis and then try to plan. If we can plan ahead of time, we'll be able to protect more assets. How fast do I need to act once a crisis hits? I think you call your attorney immediately. If someone's going into a nursing home or it's looking like that, somebody goes into the hospital, you want to make sure you're contacting your attorney immediately because there might be some spend downs that have to happen. You might need to rearrange some assets. You could buy irrevocable burial CDs or pre-plan your funeral. So there are things that your attorney is going to advise you to do if one spouse needs nursing home care in order to try to protect assets. So call immediately. Delays can cause loss of retroactive benefits, a reduced community spouse resource allowance for the spouse, higher risk of transfer penalties. Early planning is going to maximize financial protection and options. So the answer to this is call immediately. If my income is too high, can I still qualify for Medicaid? Yes, there are planning techniques that you can use to help qualify for Medicaid. Now, sometimes you may not want to. You may not want to apply for Medicaid. Some of that might be you don't want to provide all of the documentation they're going to require. Remember, facilities, there are facilities that may or may not accept Medicaid. So you want to think through that too and talk to your attorney about that to make sure that this is a facility that would accept Medicaid. And again, we want to make sure that you're medically eligible for Medicaid. Okay, so that was a really quick and dirty overview of crisis planning. Here we have our address, 20 East 6th Street, Suite 206, and we have our number, 717-655-2676 to schedule a consultation. And I'm just going to close with this. If you are someone who is concerned about long-term care, consult with your attorney, make an appointment, because again, if you pre-plan, if you talk to your attorney about ways to protect assets prior to someone actually needing care, then you can protect more assets in the long run. And you're more likely to make it through the 5-year look back period. So if when you're thinking through your estate plan, we always ask clients to list their goals. If one of your goals is to protect assets, and it could be, or to protect the spouse, if one of you would need care, then consult with your attorney because the pre-planning, planning ahead and doing trusts does allow you to protect more assets. The crisis planning is just in a situation where, for whatever reason, you weren't able to make it through the look back period or you didn't do the planning. And we're in a situation where we're trying to do the best we can. So crisis planning works, but if you want to protect the maximum amount of assets, then I would recommend you talk to your attorney about pre-planning, long-term care planning prior to someone needing care. So I hope you enjoyed today's session on crisis planning. You can always check out our YouTube channel. We are always trying to put up monthly virtual seminars. There's ones on our website that you can access our YouTube channel, or you can just go directly to YouTube. I appreciate you being here and listening. I hope you have a great rest of your day. Thank you so much. Bye-bye.